Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are going to be continuing our pretrial interest in and coverage of New Jersey versus Sean Higgins. So this happened yesterday. If you're watching live, this happened yesterday. Today is the 22nd. This happened on the 21st of August. And we are covering this trial. We've done a couple pretrials already. And for those that are not familiar with this, I've kind of been out of it for a couple months too, and been focusing on other trials as they come up. So I'm going to play some news. I'm going to play the night that this happened, so you can see him with law enforcement getting arrested, and then we're going to play what happened in court. So I just want to welcome in everybody. Thank you guys for joining us. Really appreciate it. Selena K, Crazy Mary Joe, Sinbad's fixing some dinner. Good. Mike Morrow, good to see you. Are you in the right place? Who am I and where am I? You were portaled over. Missy Russell, thank you for joining us. Clarinet Girls, yes, such a sad case of the two very close brothers and hockey players. Red Snap, I know nothing about this. Sit back, I'll try and get us as much up to speed as we can. Here, let me go over here while I'm talking. We can kind of get up to speed together again. Let's see, Golden Girl, I don't know anything either. Deb Uno, tragic, the brothers killed by drunkenness. Selena, I love NHL hockey, so I followed both of these brothers. Sharon, two brothers, ice hockey players, were in town to be in their sister's wedding, went bike riding on a country road, were struck and deleted by Sean Higgins. That's pretty much it. The McCormick family, hello to you. Iowa Backyard, thank you for liking. Psychosaurus Rex, make sure you're all booping the like while we settle in. Katrina. Sorry, Katrina. We're back. Yes. Was Sean drunk? Yeah, he had a .087. So the legal limit is .08. So by the time he was tested, .087. He's still over. Mel Stiller, you made it. Awesome. Arwen, we are all beamed over. Yes. Katie Cat, how's everyone doing today? Alice made it as well. Shelly Beans, I did some Googling on it. Arwen, beam us over, Scotty. Yes. Deborah saying hi, everybody. Nan R. Ellen, I'm so tired I cannot sleep. So I'm so tired I cannot sleep. So my sorry bum is back here again. Thanks. Short life. All right, you guys. So here's the deal. So this happened August 29th, 2024, and I'm going to play one news clip, and then I'm going to play the night that this happened. So we'll kind of all get up to speed again. So Sean Higgins, on the bottom there, he's the defendant, age 44. Matthew Gaudreau and Johnny Gaudreau. Johnny was known as Johnny Hockey. He was 31. His younger brother, Matthew, was also a very good hockey player, just not as recognized or didn't make it as far, I suppose you could say, as Johnny. Johnny was drafted. I think I have it in the description here. Let me see. Let's see if I can. Do I have it in the description? All right. I do not have it in the description. I think he was drafted like in the 4th round by the Calgary Flames. Then he went over to, who's it? The Stars. Calgary. Oh, Jesus. The Calgary Stars. I'm not as big a hockey fan as I am all the other sports. Is it the Calgary Stars and the Columbus Blue Flames? I think that's what it was. So anyway, he was, let me see here. So yes, okay. So Johnny Gaudreau was 11 years in the NHL, National Hockey League. He began the Calgary Flames, of course. What am I saying? The Calgary Flames. He was selected in the 4th round, why is that? No, he was selected in the 4th round, 104th overall. Then he played for the Flames from 2014 to 2022. Then he went to the Columbus Blue Jackets, where he played from July 2022 to when he unfortunately he was hit and killed. Now Matthew is his younger brother. He pursued hockey mostly in the minor leagues. He played for several teams in the AHL, which is the American Hockey League, and also the European. He played with the Bridgeport Sound Tigers, the Worcestershire Railers, the Reading Royals, so this was all in the UK. He also played for the Stockton Heat, which is, I guess, the American Hockey League, AHL. So, Sean Higgins, he had a BAC, blood alcohol level, of 0.087. Now, there was two drivers in front of him. One driver says that he was coming up aggressively and he was like, and it was nighttime, right? So he's going around, trying to get past them. What Sean Higgins says is that he tried to pass. There was the driver in front of the car he's trying to pass, pulls in front of him, so he pulls over to the right, and that's when he says that he hits the two. So depends on who do you believe, what you believe, all that stuff. So, all right. So with that, let's get to the news. This is the initial what happened. Let's get to the news here. Let me pull myself up here. All right, so this is the news. Let's check this out.
The man accused in the drunk driving crash that killed NHL hockey star Johnny Gaudreau and his brother Matthew faced a judge today. Sean Higgins had a post-indictment arraignment hearing this morning where he rejected a plea deal that would have saw him spend decades in prison. Now, his attorneys entered a not guilty plea on his behalf as a formality to allow the proceedings to move forward. Last month, the grand jury indicted Higgins on reckless vehicular homicide and other charges. The deadly crash happened in Oldmans Township, Salem County, on August 29th as the Gaudreau brothers were out riding their bicycles.
Let's say that's like a really, really quick clip. That's a really quick clip. All right, so this is Sean Higgins, and he was in the Army Reserve, right? We looked that up yesterday. Let's do that again. So he was a field artillery sergeant. He was a field artillery officer assigned to the New Jersey Army National Guard Joint Force Headquarters. Higgins is a part-time traditional drill status guardsman and was not on duty at the time of the incident. We also learned, he worked at a rehab facility in Gaudenzia, wherever that is. Is that how you pronounce that? He's an employee of Gaudenzia? I don't even know what that is. What is Gaudenzia? What is this? Hold on a sec. What the heck is this? It is a treatment plan. Gaudenzia. So Gaudenzia is a let's see, what is it about us? Gaudenzia was founded in 1968 by a conscientious group of community leaders who wanted to help themselves and each other overcome the challenges of drug and alcohol use. They soon learned that a collective group was much stronger than an individual struggling alone. So over the next 55 years, Gaudenzia began serving those in need of treatment for substance use and co-occurring disorders, becoming one of the nation's first providers with programs designed to meet the needs of pregnant and parenting women, populations affected by HIV, AIDS, and individuals with criminal justice involvement. Today, Gaudenzia is one of the largest nonprofit substance use and co-occurring disorder treatment providers in the North U.S., serving Pennsylvania, Delaware, Maryland, and Washington, D.C. So this is where Sean Higgins worked. Sean Higgins worked there. He also was active in the New Jersey Army National Guard. So police say Higgins was traveling north on Pennsylvania Auburn Road in a Jeep Grand Cherokee when he allegedly attempted to pass a slower moving sedan and an SUV. Police say Higgins entered the southbound lane of the roadway and passed the sedan. When he attempted to re-enter the northbound lane, police said the SUV in front of him moved into the middle of the roadway, splitting the north and south lanes, in order to safely pass two bicyclists on the right side of the road. Higgins then attempted to pass the SUV on the right and struck the Gaudreau brothers from behind. So the brothers died from their injuries. According to the police affidavit, the trooper who arrived on the scene detected a strong odor of alcohol, and Higgins allegedly told the trooper he had consumed 5 to 6 beers before the crash. We're going to go check that out right now. Let's check that out right now. We're going to watch this right now.
All right.
So we're going to check this out right now. So Higgins allegedly told investigators that he thought the driver of the SUV was trying to stop him from passing. Higgins told investigators that his consumption of alcohol contributed to his impatience and reckless driving. Witnesses reportedly told police that they observed Higgins approaching them from behind, adding that he appeared to be traveling at a high rate of speed. So he's been cited with driving while intoxicated, reckless driving, possession of an open container, improper passing, and consuming alcohol in a motor vehicle. All right, so here we go. Let me put on the closed captioning. All right, so this is about 9 minutes, and then we'll get to the hearing.
Where were you coming from, sir?
Taco Bell in Pennsville.
Here's your ID. Where were you before Taco Bell?
My house.
Okay, how much have you had to drink today?
I mean, I've been drinking beers, but I haven't had one in like 2 hours.
Okay.
So since the accident, like probably an hour or so.
Okay.
Yeah.
I'm going to run you through a few tests.
Yeah, that's
All
fine.
right, go ahead and put that cigarette out.
Yeah. And just FYI, I had surgery on my knee on Friday, so
Okay.
I'm gipping around.
All right, we'll get there.
Man.
Kill the lights in front of your car real quick.
Sure.
Step over here for me.
Alright. Give me a second.
Just back right up to his car.
Yep.
The lights for me. Yeah. Excuse me.
Yep.
Alright, what I want you to do, just so you're kind of more my height, is lean back into that bumper, kind of sit on it. Lower, right there. Alright. See the tip of my pen?
Yep.
I want you to follow that with your eyes and your eyes only. Don't move your head, okay?
Okay.
The tip, up here.
The top tip or
Yep,
bottom
the top
tip?
tip.
Okay.
See it?
Yep.
You don't wear contacts?
No.
No? No problems with your eyes?
No.
Alright, and you're not injured as a result of the accident?
I'm just freaked out.
Okay. Alright, follow the tip. Don't move your head.
Now, keep in mind, I just posted that, I don't have my chat connected. I just posted that the Gaudreau brothers were drinking. Yes, their blood alcohol was 0.129 and 0.134. Legal limit is 0.08. So yeah, they were pretty drunk. That being said, it was their sister's wedding. They went out, they were drinking, whatever, but they were on bicycles. So one of the hearings, one of the last hearings, the defense was trying to say, oh, well, they were drunk, so it was their fault. They were more drunk than my client, so it was their fault. So that was one of their arguments, was that the brothers were more drunk than Higgins, so it was their fault that, this happened. So
just the tip.
Yep.
Step out, go right to the center of the road.
The alarm is against the alarm. You're right here.
Go right here to the line.
Yep.
Alright, stay right there and face me. You mentioned surgery to your knee. How long ago was that?
Friday.
Friday. Is it affecting you right now?
I mean, I'm dipping around, yeah.
Alright, at any point if you're in pain, just let me know.
Yeah.
Alright. The first test we're going to do is the walk and turn. I'm going to put you in the starting position. I want you to hold that starting position until I tell you to begin the test. You understand?
Yep.
Starting position is going to be your right foot in front of your left foot, touching heel to toe just like this.
Yep.
Hands down at your side. Alright? Do you want to take your flip-flops off or you want to leave them on?
I'll leave them on.
Alright, so you can take that position. Right foot in front of your left foot, hands down at your side. Alright? When I tell you to begin, you're going to take 9 heel-to-toe steps forward, counting each step out loud. Upon the completion of 9 steps, you're going to keep the front foot planted, series of small steps with your other foot, and turn around. Okay, it's going to look like this. 1, 2, 3. I'm doing 3 for demonstration, you're going to do 9. Completion of 9 steps, keeping that front foot planted, series of small steps with your other foot, and 9 heel-to-toe steps back. 1, 2, 3. The entire time, you're keeping your hands down at your side, you're looking down at your foot and counting out loud.
Okay.
Once you start the test, do not stop until you've completed it.
Got it.
You understand?
Yes.
You may begin.
1, 2, 3, 4, 5, 6, 7, 8, 9. Ow. Keep going.
Like I explained, 9 steps forward, series of small steps, 9 back.
Ow. Sorry. 1, 2, 3, 4, 5, 6.
Good?
Yeah.
All right.
The other thing I want to point out while you guys are watching this, look at how desolate it is. I mean, this is a country road. There are no lights, there's no street lights, there's no lamps, there's no, city lights, there's no house lights even. I found the picture before. I think there's even I think it's a cornfield, to be quite honest. I'll try and find that picture and I'll post it. But as you're watching this look around and it's dark. So, it's pretty dark.
Next test you're going to do is the 1-leg stand. All right, again, I'm going to put you in the starting position. You're going to hold that starting position until I tell you to begin the test.
Okay.
You understand?
Yep.
Starting position is both hands down to your side, both feet together. Just like that.
Yep.
Touch both feet. All right. When I tell you to begin, you're going to raise one leg of your choosing approximately 6 inches off the ground. Keep the bottom of your foot parallel to the ground, look down at your foot and count out loud 1001, 1002, 1003, and so on until I tell you to stop. Remember, you can raise either leg, whatever's going to be best for you and your knee.
Yeah.
All right, so I'm going to demonstrate 1001, 1002, 1003, and so on until I tell you to stop.
Okay.
Do you understand the directions?
Yep.
You may begin.
1001, 1002, 1003, 1004, 1005, 1006. I'm sorry, I'm just freaked out. Like, what am I supposed to be doing again?
You're counting it out loud until I tell you to stop.
Okay, 1001, 1002, 1003, 1004, 1005, 1006, 2007, 2008, 2009, 10,000, 11,000. It's getting hard.
All right, you said it's been about an hour since your last drink?
About that, yeah.
And how many did you drink?
I mean, since like noon today, like 5 or 6.
6 since noon?
Yeah.
Beer or what was it?
Beer. Just beer. Normal light.
Alright, turn around and place your hands behind your back. I'm gonna take this watch off, okay?
Yep.
Yeah, we'll grab everything. What do you need? Your phone, your wallet? Where's that at? I'm seeing where's your phone?
You want to put them in the back of your car? Or one? I got flying against the car. I drove up there. One of them. We're gonna search.
I'll do it. I'm just search you right here, right?
This is your car, Joe?
Yeah, we're gonna go to that car. I'm gonna do it right here, all right? Yep. All your stuff in the car, the registration is all stuff gonna be in there towards that car. Just throw me the money.
What's your name again, man?
Sean.
Sean, I'm just going to read you this and use your verbal acknowledgement, okay? You have the right to remain silent and refuse to answer any questions. Do you understand?
Yeah.
Anything you say may be used against you in the court of law. Do you understand?
Yeah.
You have the right to consult with an attorney at any time and have him or her present before and during questioning. Do you understand?
Yes.
If you cannot afford an attorney, won't be provided if you so desire prior to any questioning. Do you understand? Decision to speak to us is not final. You may stop talking to us at any time. Do you understand?
Got it back.
Is everybody okay back there? I mean, what happened?
We'll talk about that when we get to the station.
Outside.
All right. I agree with you. Mike and Red Snap, Aaron and I watch a lot of drunk people, drunk body cams. We watch a lot of that. And stone sober, when they put their head back like that, if I do that standing up, I'll fall over. I can't do it. I'll get dizzy. I'm like, I couldn't do that sober, let alone having, what did he say? He was drinking from 12 to 5. He had like 6 or 7 beers. No way. Standing on one leg, maybe I could do that. I don't know. But when you tip your head back, that just throws me off to no end. Here's the other thing I wanted to show you. All right, so here's what happened. Here's what happened. See if I can blow this up a little bit. So, all right, so here's what happened. That's as big as I can get it. All right, so the boys are driving. The brothers are biking on the side. Yes, it's a dark country road. Yes, they were drinking, but could they have called an Uber or a Lyft? Sure, I guess. In hindsight, they probably, I'm sure their wives and their family members and their friends are saying, why didn't you guys call an Uber? I don't know. Maybe there were some bikes just there and they grabbed them. They went to go drink it's the night before the wedding and they, it is what it is, So they're riding a bike on a country road at night. I don't know, when did this happen? When did this actually happen? Meaning, what time of day? So what time of day? It was at 8:20 p.m. So it was dark. Well, it was August. It was August. So Jersey, 8:30 in August. It was probably still somewhat light. I don't think it was dark like that. I don't think it was pitch black. So it was probably somewhat, probably dusk, right? People that live in Jersey, August. Well, right now, August 29th. What is it like? My peeps that live up in Jersey or New York or Pennsylvania. Anybody that's up in that area. Long Island, Ohio even. Is it still somewhat light at 8:20? Let me know. So anyway, so Higgins is coming up on these two cars. He tries to pass them on the left. The one car in front pulls out in front of him because he's trying to avoid these bicyclists. There's two bicyclists. So he pulls over, he pulls out. Higgins thinks that this guy's being all aggressive, so he pulls over and then boom, he hits the two. Is it dark then? At 8:30? Gosh, I remember growing up in Cleveland, it was light until like 9:30. I mean, like light. August, isn't it starting to get dark? Starts to get dark at 8:30. Starts to get dark. 8:30. August is not setting sun, still light out. That's what I don't, it's not pitch black. No way. Yeah, Mac, aren't you there? Don't you live like in that area? I think it's not pitch black. No way is it pitch black. Right? It's still fairly light out. Selena says it would still be light at that point in the summer. Yeah, it's not right. It's no way is it pitch black. Again, I remember growing up in Cleveland, and we would stay out till 9:30, and it was still, dusk, if you will. So my point is it wasn't pitch black. So maybe they would have been home in 5 minutes. I don't know. I'm not sure where they were staying. I don't know where they were going from where to where, Bikers were on there. Yeah, the bikers were illegal. Dark at 8:30 now where you are. In July, it was light until 10, Chris says. Sharon, 8:30 in July, August, it's dark, no streetlights. In that area, right? You guys are in Jersey. I only want people that are in New Jersey or New York, in New York City, because this happened in Philadelphia. So only respond if you're like in the Philadelphia area or like-minded in there. Because I want to know if it's, when does the sun set? When does the sun set in Philadelphia? 7:47, the sun goes down. So this happened at 8:30. So 7:47, the sun goes down. All right. So at 8:20. All right, fair enough. It is probably... So it's still light 70 to 140 minutes after the sun goes down. So there's still twilight. All right. 7:48. I got 7:47. So this was like a half hour afterwards. The sun went down a half hour. Psychosaurus Rex says, even if Higgins got cut off by another car, he was driving while intoxicated, and thus the liability is on him. Not to mention pedestrians have the right of way even on bikes, I believe. Oh, 100%. Now it's about 8:30. Katie Cat, it was pretty dark then. Maybe a hint of light left, but still dark. Philadelphia is in Pennsylvania. That is correct. All he had to do was slow down and be patient. Impulsive decision on his part. He admits it. He admits that he was. Impatient. He does admit that. Based Blonde says, did the bikes have lights on them? I don't know that. We don't know. I don't know that yet. Sure Life, but as long as they have proper lights on the bikes and the right bike trail, they are fine. He was trying to pass on the right side of the law. He was trying to pass initially, and then he says the car he felt cut him off, but in fact that SUV or truck, I guess, was trying to avoid the brothers. So he jerks back, and then that's when he hit them. It's really sad, I always think about these moments. It's like just that 1 second. It's just like it literally was 1 second. If Higgins had been caught at a stoplight, if Higgins had tried to avoid, a skunk running across the road and slowed down, just 1 split second, literally 1 split second earlier, the brothers would have been somewhere else, or if they had had one less drink or one more drink, they wouldn't be there. You know what I'm saying? It's like just that one. When things like this happen, I always spin out and I always think about what all the things that could have been done to make them just that 10 seconds either further down the road or further up the road, and this wouldn't have happened. I mean, think of all that needed to happen to fall into place for this to happen. That's where my mind goes sometimes. All right. So with all that being said, let's get to the actual hearing, which was yesterday. Now this was a motion to suppress evidence, right? This was a motion to suppress evidence about the vehicle that was driven, because he hits the brothers and he continues on. He doesn't flee the scene, but he continues on for like another 100 yards or something like that. So, all right, yeah, you guys do the same thing. Yeah, I mean, it's just when things like that happen, it's like if you're walking down the street and something falls on you, you're like, just a split second, one way or the other, you wouldn't be in that situation. All right, so this was he hits the brothers and he continues on, I think, for about 100 yards, something like that. And so this hearing was to suppress the evidence that was obtained through his vehicle. So let's get to this. So this is the actual hearing from yesterday.
All right.
And I'll put on closed captioning so we can check it out. All right.
Thank you.
Just like 1 minute, please.
Sure.
Yeah. Just 1 second. I have to ask a question.
Sure.
Oh, yeah. Okay, it's not going to. Thanks, Judge.
Ladies and gentlemen, we're going to go on the record. This is now the matter of State of New Jersey versus Sean Higgins under indictment 2412-400I. Counsel, your appearances, please.
Good afternoon, Your Honor. Michael Mester, appearing on behalf of the state.
Good afternoon, Your Honor. Richard F. Kleinberg III with co-counsel on behalf of defendant.
Judge, thank you. Good afternoon. For the record, it's Matthew Portella, his co-counsel for Mr. Higgins with Mr. Kleinberg.
All right, very well. This is a motion to suppress filed by the defense. This motion specifically deals with the search of the interior of the vehicle operated by Mr. Higgins. At this point, I'll ask Mr. Portella or Mr. Kleinberg, whichever one of you is going to proceed to present your argument.
Thank you, Your Honor. Your Honor, if I may.
You may have
As you stated, this had to do with a search of the vehicle, but it's beyond the search of the vehicle per se. The physical search warrant for and I'll refer to it as the Jeep, for the motor vehicle of Mr. Higgins, was signed by Judge DePersia and conducted on September 4th of 2024. As part of the physical search warrant that was entered, as per Trooper Pope in his crash investigation report, which was attached to the motion, Trooper Pope stated that he, quote, conducted an image of the event data record, the EDR, within the Jeep, specifically referred to as the airbag control module, which I shortened as the ACM. That's through the BOS Crash Data Retrieval System 24.1.289, was utilized to image the data stored in the ACM as a result of the crash. And that's set forth in the investigative report at page 11. So we'll start with that. We have a search warrant, and it's for the physical contents of the vehicle itself. We have in the report provided by the state that it went beyond just taking an item out of the car or photographing an item out of the car. That item was removed from the car, then placed into another device or with another device in order to extract data, which then allowed them to take an image of that data and utilize it in the report. Trooper Pope goes on to write, quote, the recovered data as indicated that one event was captured by the ACM. However, this event was determined not to be related to this crash. It talked about the fact that it was from a previous matter. As it relates to the infotainment system, then, Trooper Pope writes, Detective McGrady entered the Higgins Jeep and performed an extraction of the Uconnect 4C electronic control unit from the vehicle. Detective McGrady kept the unit in his possession and later removed the motherboard containing the data chip from the Uconnect 4C. But data acquisition was not possible using the equipment available to him. He advised that the data would have to be retrieved via a chip-off style acquisition performed by the New Jersey State Police Cyber Crimes Unit. This is set forth in Pope's crash investigation report at page 12. He then writes, due to this being past a 12-day search warrant, Detective Hall would have to author a new combined search warrant and communications data warrant specifically related to the chip-off procedure. Results of this is still pending, and that's on page 13 of the report. On the 23rd of December of 2024, Detective Hall emailed counsel with the most recent CDW, which was signed on October 8th by Judge Eslack and was executed on October 10th. And they were both attached to the brief as well. To begin, Your Honor, counsel received Trooper Pope's crash report on October 10th, 2 days after Judge Eslack signed the CDW. In the crash report, specifically Appendix E, there's 34 pages of crash data, which is seemingly relied upon in the investigation. However, according to Trooper Pope's own report, the crash data that they were able to retrieve is from an unrelated incident, which happened about 80,000 miles prior. What I mean by 80,000 miles, not along the road, but prior to that date. Secondly, when we're looking at this report, it's important to note that only a physical search warrant was granted initially. Now, this would give the state the ability to physically remove items from Mr. Higgins' Jeep, which they did. They physically removed the infotainment system. However, the ACM produces stored data that is held, and it would be the equivalent of a hard drive in a computer or even within my cell phone. So if there's a search warrant to then say, okay, we're going to take everything out of the car, and in the car is a cell phone. Case law, common sense would then dictate that in order for an extraction to be done as to what's inside of this, it would have to have a CDW. It's a separate step that needs to be taken. It's not something that you could look at and say, what is in this? Seemingly, if this was the ACM that was removed, again, you can't look at it and say, well, we can see that this information is here. And granted, if on the exterior, just like on my phone, it had the date and time, that would be one thing that was in a report. The issue then comes when you take that additional step, connect this to the equivalent of a USB type device or data C cable and extract from it and put on a computer screen what's inside of it, and then take that information and utilize it. It's that additional step is the issue that the basis of the motion is for here today. Again, while they properly did remove the information system, this was done without a CDW. And the question then comes about, can this be extracted properly without a CDW? And if so, how? Case law is clear. In this case, the physical search warrant would only legally be a sufficient basis to get the actual item, not the information inside. The chip-off procedure is required to extract the data from the information system, which is important here, Judge. If not for that first step, it never would get to the next step. When you look at the investigation as a whole, there seems to be a mistake here or a backtrack. The state received a physical search warrant on September 4th. The state entered the Jeep legally to remove the items at that point. They then illegally extracted the data from the ACM due to the absence of a CDW. They then realized that, wait a second, we took this data out, we're using this data, we didn't have a CDW, let's go back and apply for a CDW to then do the chip-off procedure and use this information. Now, what was concerning is the state, by that point, had already essentially completed a crash investigation report, which was heavily relied upon this data. Now, in the state's brief, they claimed that a CDW is not even needed for this because it relates to the New Jersey wiretap law. While it does relate to the New Jersey wiretap law, that's not factually nor legally correct. New Jersey requires a CDW, which is the equivalent of a search warrant, to search the contents of any electronically stored information, whether it's on phones or computers. That includes stored text, emails, photos, videos, app data, any sort of history or electronically stored information. Based upon Riley versus California, the United States Supreme Court said that police cannot search items such as a phone or electronically stored data as simply as search incident to arrest. You must have a warrant. New Jersey fully adopted this into its CDW framework. Now, a wiretap order, and I would agree, if audio was involved, then we're talking a different animal altogether. When audio is involved, the New Jersey Attorney General CDW manual, which was cited in the In Re application, State of New Jersey Active 2017, says if there's an audio portion, a wiretap order is necessary. However, a search for other electronic items without audio or photos, specifically, if you talked about a cell phone, would require a CDW beyond that of a regular search warrant. The language makes clear that stored contents means a CDW must be utilized to retrieve those stored contents by electronic means, unless you're intercepting live audio, which then requires a wiretap order. Judge, this is set forth under 2A, 156A, 29A, Rule 3.5, as well as the case law. I would also direct the court's attention to Facebook versus the State of New Jersey by the Supreme Court of New Jersey, which was decided in 2023, where it says that, quote, a CDW is the equivalent of a search warrant, and they're citing State versus Lunsford 2016. Like a standard search warrant, a CDW can be issued based upon a showing of probable cause. State v. Finesmith 2, Active 2009. It is not subject to more specific, restrictive, and enhanced protections such as the Wiretap Act. However, federal and state law define electronic storage as any temporary, immediate storage, past storage, or information of a wire electronic communication, information, or transmission by electronic service for the purpose of backup protection of said information. And that's codified under both 2A:156A-2Q under New Jersey law, as well as 18 U.S.C. Section 2510, subsection 17 of the federal law. What we have here again, Judge, is it's basic. We don't disagree that the state had the right to go in and take the physical object. The damning part and the injury comes about when you take that extra step and remove that data and utilize it in the report and going forward as the basis for additional information. What we're asking for is to suppress any of the information that came from that extraction going forward. And under Wong's Son, that being fruit of the poisonous tree, any information that was derived therefrom. Thank you, Your Honor.
Mr. Kleinberg.
Yes, Judge.
Two quick questions. So the initial search warrant, which was authored by Judge Persia,
Correct.
August 30th, 2024, executed 9/4/2024, gave the state police the ability to capture and remove the airbag control module.
Correct.
No dispute.
Yes.
The information that was discerned from the airbag control module related to something that happened approximately 75,000 to 80,000 miles earlier on the.
Yes.
Fast forward to October 8, 2024, Judge Eastlack signs 2 search warrants, one a search warrant, one a CDW. The CDW specifically is regarding the infotainment system. My understanding is that there was nothing at all, at least from what I've read in any of the reports, captured from the infotainment system, from the SanDisk, from the SD card, until after Judge Eastlack's warrant was signed and executed.
Correct.
Are we all on the same?
Yes.
And it's my understanding that that's the information, obviously, that the state wishes to rely upon, not the information that was in the airbag control module.
But if you read through the way the reports are set up, if not for the initial download of the ACM, that information never would have led to the CDW. And if you look at the report, it seems highly unlikely that within a 2-day period, I believe how many pages this report is, but this report was then turned over utilizing a lot of the information from the first down.
Right.
So the argument is, if not for the initial download, the CDW never would have been requested. If this was done properly in the beginning, if a CDW was done simultaneously with the first step, we wouldn't be here right now. We'll start with that. Secondly, it would not have had to go back to Judge Eastlack and get that, to go back and read it, because the proper information wasn't there. If the proper equipment. And I think we have to look at the fact, it says straightforward in the report that the extraction, when they did attempt to do the extraction, could not be done because they did not have the proper equipment to do so then. So it's a situation where, okay, we're doing this, we don't have the proper equipment, warrant runs out, let's go get another warrant, come back, and then do it the right way. This is not a continuation argument either the state could make, because a continuation argument would have been one in which they had a CDW already and was in the middle of extracting it when a warrant ran out. Then there would be a valid argument, and I would not be standing here right now saying that, okay, the state did something wrong. No. If they had a CDW at the time that the initial extraction started, and they realized we don't have the right equipment and went back and asked to extend the warrant, that would be okay. Or even if it went beyond the time and they took that additional step and extended, the problem is there was no CDW in which to extend. And under New Jersey law, whenever they talk about the extending doctrine, when it comes to that, it has always been one in which it was a proper warrant first. I believe the leading case, and I can't remember off the top of my head, did involve the search of computers for child pornography. And during that search, when they went to the individual's house, they started searching the hard drives of the CPUs and standalone computers, at which point they then realized that there was a laptop hidden. They then went beyond the warrant and searched the laptop based upon the CW, but it was beyond the time. And the court said, that's okay, because there was already a CDW, now it's a continuation. The courts have held situations, though, where there was not a CDW and you stop in the middle, where here they completed it and said, oh no, we need to do this the right way now. We don't have the right equipment. Let's now get the warrant and continue it. So the argument is, if not for the initial wrongdoing, the wrongdoing being the extraction without a CDW, we never would have gotten to that next step. And they should not be, in other words, granted some sort of special privilege simply because they went a couple days afterward and said, we couldn't do it with this equipment. We need a warrant to do this now. It almost seems, and there's no indication of it, but if you look at it, common sense would dictate, it almost was a situation they're running it out of time, can't do it, and realize, oh no, we don't have a CEW. We might as well get one this time when we go back.
Thank you, Mr. Kleinberg.
No, Judge.
Mr. Meston?
Thank you, Your Honor. I know Your Honor reads the briefings thoroughly, so I'm not going to regurgitate my brief. And I know you read the exhibits that are provided as well, one of which was Trooper Pope's report. A thorough reading of that report would indicate that the state did not rely on the download from the airbag control module, but there was a reliance of the complete and thorough investigation that Trooper Pope conducted at the roadside crash on the day in question. The inclusion of the download from the airbag control module was just to provide a complete and thorough report and to provide defense counsel with the information that they can download it on the day in question when they did the search of the airbag control module. Nothing more, nothing less. There was no reliance on that information to come to that final conclusion. There was no reliance on that information when Detective Sergeant Hall applied for the search warrant and CDW on the later date. So the argument of a fruit of the poisonous tree should fall flat on its face because there was no reliance on that first search to acquire that subsequent search warrant. The analogy of the cell phone to the airbag control module also should fall flat on its face because an airbag control module is a standalone computer in the car that only records information from sensors in the car. There's no communications from the occupants in the car to other occupants in the car or people outside of the car. The computer data warrants are a product of the Wiretap Act that are to protect communications between citizens of New Jersey. And there's no communications that are recorded in the airbag control module.
And let me just interrupt you for a moment. So I take it it's the state's position that the initial warrant signed by Judge DePergia, which was the warrant dated August 30th, executed on September 4th, would have allowed state police not only to obtain the airbag control module, but also to extract information from that without the necessity of a CDW.
Correct, Your Honor. And I believe it was the affidavit that Trooper Alenardo submitted outlined all of that. The warrant that was signed by Judge DePergia gave the troopers authority to actually go into the car and extract not only physical evidence, but electronic evidence from the computers in the car. It was expressly written into the warrant. And I cited that in my brief, Your Honor. And expressly stated in the affidavit and in the warrant, the airbag control module. That is something that is typically searched in cases like that. The airbag control module has vital information in crashes. It has information that is stored that investigators need to be able to reconstruct what happened right before a crash happens. There is no communications. There's nothing private associated with a driver and occupant of a vehicle that is protected under the Fourth Amendment. This was a clean search. It is a clean affidavit, a clean search warrant. It carries the presumption of validity, and there's no reason to overturn any of that. The CDW was valid as well. As I indicated in my report, Detective Sergeant Hall provided 3.5 pages of explanation regarding the infotainment center and that how they work and why they were requesting a CDW. There had been no information downloaded from that infotainment center prior to requesting that CDW. They did a combination search warrant and CDW. And it was thoroughly explained to Judge Eastlack in the affidavit of probable cause. If Judge Eastlack had any questions, he had an opportunity to ask Detective Sergeant Hall prior to signing the search warrant. There was no search outside of the four corners of either search warrant. I believe that the searches should stand. There shouldn't be any suppression of any of the evidence in this case, Your Honor.
And Mr. Messman, assume for argument's sake that the airbag control module would have required a CDW to extract information from. Would that have created a situation whereby, at least in the state's mind, that the infotainment system, the vehicle infotainment system, would not have been able to be searched? In other words, had you acquired this information from the airbag control module, which, according to at least your papers,
Right.
your responsive papers, has no real relevance to the case.
Correct.
The fact that a CDW was granted for the infotainment system subsequent to that initial warrant,
Right.
and subsequent to the initial search, would that not have been information being sought by the state anyway? In other words, if you would have recovered viable information from the airbag control model, my understanding is the airbags didn't deploy.
Correct.
Because of the nature of the accident.
Correct, Your Honor.
Had you recovered viable information from that airbag control module, would there still have been a request for the CDW for the infotainment system, is what I'm getting
That would have to be a question for the investigators, to be honest, Your Honor. And it would depend. That's a highly fact-sensitive question. It would depend on what type of information was garnered from the airbag control module, because there is a lot of information that can be gained from that airbag control module, because it's yaw rate, speed, braking, the amount of braking, all that kind of stuff. So depending on what that information is gained, they might not need any information. But if there's only a certain amount of that information, they want to try and get some more information, they might have needed to get a second CDW for that infotainment center. So it's highly fact sensitive, and I don't mean to dodge the question.
No, you're not.
But it depends on the situation, Your Honor.
But once that system doesn't engage, none of that information is recorded.
Correct.
So therefore, next step is we check the info.
Correct. And these are new systems, and this is kind of one of the first times that they were able to get this type of information from the infotainment system.
Thank you, Mr. Messman. Mr. Kleinberger, any follow-up?
No, Judge, the only follow-up would be with regard to state's argument that the original regular search requested this information, including downloading electronic computer diagnostic systems, event data recording, ACM, or any other mechanical. Just because it requested doesn't mean it was done right. And there's still the argument that that additional step of doing the download under statute, as well as case law, would require a CDW.
Mr. Kleinberger, in that regard, and I know you obviously cited case law, you cited it in brief as well as on the record today. And I looked, and maybe if I missed it, I didn't see it. Is there any case law that specifically says in order to retrieve data from the airbag control module, a CDW is needed?
It doesn't exist. So there's no case law on point.
I didn't see any.
There isn't any. I searched throughout. The closest we could come is it just discusses, and as I said, Judge, went through the dicta in the Facebook case from 2023, where it talked about the mirroring of the federal statute and defines electronic storage, where it says you need a CDW, as any temporary or immediate storage of electronic communication, transmission, information, including the backup protection, and goes through a whole list: photographs, apps, history, any ESI, electronically stored information.
Thank you, Mr. Kleinberg. Based upon the arguments made by counsel on the record today. I know there are witnesses that were subpoenaed. Does either counsel feel the need to call any of those witnesses to testify?
Judge.
Not from the state's perspective, to be honest.
What I'm going to do now is I'm going to take a short recess, assimilate your arguments, and then I'm going to come back briefly on the record with my decision.
Thanks, Judge.
Thank you, Honor.
Right. Yeah. All right, we're back on the record in the matter of State of New Jersey versus Sean Higgins. I've been able to listen to the argument made by both counsel in this matter, as well as review the documentation submitted to the court. This matter emanates from a motor vehicle accident which occurred on August 29th, 2024 in the area of 63 Pennsville Auburn Road. As a result of the motor vehicle accident, evidence was adduced that Mr. Higgins was operating a Jeep Grand Cherokee at the time of the collision. As a result, he collided with two bicycles, one operated by John Gaudreau, one operated by Matthew Gaudreau, which ultimately result in fatalities. The defense has filed a motion to suppress evidence, arguing that the evidence obtained from the Jeep Grand Cherokee, specifically that obtained through the infotainment system, as well as the airbag control module, should be suppressed and should not be considered by the court or at some point in time a jury down the road. Court has reviewed substantial filings made by both counsel and obviously the thorough arguments made on the record by both counsel in this case. The court finds that on August 30th, 2024, an affidavit of probable cause was submitted to Judge Russell DePersia. Judge DePersia had an opportunity to review that affidavit of probable cause filed by Trooper Alanardo. Based upon the affidavit of probable cause that was filed at the time by Trooper Alanardo, Judge DePersia found it appropriate to issue a warrant. And I think the important language in Judge DePersia's warrant specifies as following, and I'm not going to obviously read everything, but he indicated that there may be a search and seizure of the following information. And specifically, he indicates the retrieval of any electronically or mechanically stored information or data relating to the condition and status of the vehicle and its operating systems prior to, at the time of, and post-collision. In particular, but not limited to, all data regarding the engine, powertrain, brake system, steering system, suspension system, and other parameters, such as change in velocity and seatbelt usage, utilizing and or downloading any onboard electronic computer diagnostic system, event data recorder, airbag control module, or any other electronic or mechanical source of data. And he then goes on. In the court's estimation, based upon the information supplied and based upon a review of the totality of the circumstances, which the court has to consider, there was in fact probable cause for the granting of the search warrant by Judge DePersia. I don't think anyone argues that there was no probable cause at this time. So at this time, the question becomes whether or not the airbag control module was a device that would need a search warrant, or other than a search warrant, a CDW, a communication data warrant, in order to retrieve information from it. The court, after analyzing all the information presented to it, finds that the airbag control module is a device that obtains information from the vehicle. It only obtains information from the vehicle if and when airbags are deployed. In this particular case, airbags were not deployed, so it did not capture any information from the vehicle regarding this particular crash. The only evidence of deployment was something that happened between 75 and 80,000 miles prior to this crash, which is whether or not it's evidential in any way down the road may be an issue, but right now it really has no bearing on any additional information in today's hearing, other than the fact that it was included in the accident reconstruction report to put the defense on notice that that information was in fact obtained and did in fact exist from this prior collision. So I find that the fact that the airbag control module was removed from the vehicle and data was in fact retrieved from the vehicle is in fact not improper. The fact this device does not communicate to any other device. It solely records information from the vehicle. It is not a device that has any capacity to send information out to another entity, nor does it receive information other than that from within the vehicle, and that being from the airbag deployment. And in this case, as I indicated, the airbags didn't deploy. So for those reasons, I find that Judge DePerge's warrant was in fact issued with proper probable cause, and I find that the seizure of the airbag control module to be appropriate, as well as the extraction from that device pursuant to the plain language in Judge DePerge's warrant, as well as the fact that in this court's opinion, a CDW is something that would not be required to obtain that information. That next takes us to the infotainment system. And in regard to the infotainment system, we have a warrant, an affidavit of probable cause, once again, submitted to a superior court judge, that judge being Judge Easlack. There were two warrants submitted. One was the physical search warrant, and one was the CDW. And in this case, once again, there's not a whole lot of law with regard to infotainment systems and information derived therefrom. However, there is a distinction between the infotainment system as opposed to the airbag control device, because the infotainment system could actually receive data potentially from outside the vehicle, could potentially transmit data outside from the vehicle to other sources. So the court has to consider that in its findings. Specifically, Detective Sergeant Hall applied for that warrant to extract the data from the SD card. The SD card had a SanDisk chip, which had a potential for holding more nuanced information, possibly GPS data, telecommunications records, crash records, etc., which as a result caused the Detective Sergeant to apply for the CDW. Judge Easlack reviewed that CDW. Judge Easlack found that there was adequate probable cause to issue the search warrant as well as the CDW. Once that information, once that affidavit of probable cause is submitted and considered by a superior court judge, this court has to give significant deference to that superior court judge who made that finding. At this time, there has been information extracted from the infotainment system pursuant to the CDW. This court does not find that that information, which was extracted from the infotainment system, falls within the fruit of the poisonous trade, because it was obtained pursuant to a valid CDW offered by Judge Easlack and issued by Judge Easlack. So the records, the information that was received from that infotainment system is also admissible. The motion to suppress that information is denied at this time. And if I didn't indicate, the motion to suppress the airbag control module is also denied, as both of these devices were in fact properly seized and properly searched pursuant to two valid search warrants for which there was probable cause. So I am in fact denying the defense's motion regarding both of these motions. At this point, I know we have a hearing scheduled for September the 18th for the Miranda hearing. I believe that is listed for 9 a.m. and believe they're
10 o'clock. I think there was something else going that morning.
10 a.m. I believe we have 4 witnesses who are scheduled to testify at that hearing.
Yeah, there should be 4 troopers on that one.
Counsel, anything further for today?
No,
Nothing further from the state.
no, Judge.
No, Judge, thank you.
Thank you. And I know we were listed, I think, today for an ICDC, I believe. If someone wants to correct me, Warren, DCDC. I'm going to continue it as a discretionary conference. Mr. Mester, does the state have a request?
Yes, Your Honor. I would ask for excludable time, obviously, from today into the next date. I know we had excludable time up to today for the motion. Now we have bifurcated the motion into two separate dates. I would like excludable time attributable to the defense because it is defense's motion.
Mr. Feinberg, Mr. Dell.
Judge, we have no objection to excludable time.
All right, so we're going to enter an excludable time order from today, which is August 21st, 2025, through September 18th, 2025, which we will reconvene on that day for the additional motions.
Thank you, Your Honor.
Thank you, Judge.
Thank you,
Judge.
Thank you. We are adjourned.
All right. So basically, judge denied. Judge denied them suppressing that evidence. Boink. So that was that. There was something was I going to play something else? I think that was it. I think that was always that was all I was going to play. Ellen, I hope you made it up. I hope you made it. Hope you lasted. Time for you to go get some sleep. All right. With that, guys, I will say have a let me see. With that, I'm going to let you guys go. It's Friday night. It's been a long week for us. We enjoyed you spending your Friday with us, your Friday night with us, and I think with that we're going to call it a night. So we will be back on Monday with Donna Adelson. We pick back up on that day 2. I think the lawyers are going to be there around 8:30. Judge told the jurors to show up around 9:15, to start at 9:30. I believe, is that what it was? Yep, they're supposed to report at 9:15 and they start at 9:30, but he told the lawyers to show up at 8:30. So we'll be on around 8:20, 8:25. So have a great weekend, you guys. Thank you so much for joining us. We will probably see you guys on other streams. You know, we watch other streams as well. I'm not sure does Sam have anything this weekend, or that was last weekend? Yeah. Barry does. Well, I could look. Never mind. All right, guys. Thank you for joining us. Appreciate you all. I can leave you with this. I like to leave you guys with there's Polly. She's purring. I don't know if you guys can hear her, but she's actually purring. All right. With that, guys, thank you so much. Thank you to Aaron. Thank you to our mods. Thank you to chat. Appreciate you guys. Thank you for joining us, and have a wonderful evening, a good weekend. And if you're on Replay Crew, thanks for watching. Make sure you guys drop a comment in the video. Let us know what you're thinking about this case. And we will see you guys on Monday for Donna Adelson. Have a good one. Bye.